aside.
Ma'am, we have a warrant to search this property. Step aside.
Okay, then show me the warrant.
We don't have to show you anything. We're executing
Under
a
the
lawful
Fourth
search.
Amendment, you're required to present the warrant before entry.
Step aside. Now.
Show me the warrant.
We're not doing this.
The woman inside the loft had been awake for nearly an hour before the knock came. The building was quiet the way Philadelphia neighborhoods are early on a Saturday morning, when the city feels pause between nights out and errands that haven't started yet. She had just finished a short run along the block, showered, and was standing barefoot in her kitchen waiting for the coffee machine to finish its cycle when the pounding started. It wasn't a polite knock. It was deliberate, heavy, the kind meant to establish control before a word is spoken. When she approached the door, she didn't open it all the way. The chain stayed on. Through the narrow gap, she saw 3 figures in tactical vests, police printed across their chests. The lead officer stood slightly forward, shoulders squared, already positioned as if the decision had been made before she ever reached the door. Officer Daniel Mercer had been on the force long enough to recognize hesitation and long enough to mistake composure for weakness. From his point of view, this was supposed to be routine. A search warrant. Early hour. Minimal resistance. He glanced briefly past the woman, trying to see into the space behind her. "We have a warrant to search this property," Mercer said. "Step aside." The woman didn't raise her voice. She didn't argue. She didn't move. "Then show me the warrant." It was the first off-ramp. A simple procedural step. One Mercer had taken hundreds of times before. But instead of reaching into his pocket, he chose authority. "We don't have to show you anything," he said. "We're executing a lawful search." The woman corrected him immediately. Not emotionally. Precisely. "Before entry," she said, "the warrant must be presented." Mercer shifted his weight. His 2 partners stood behind him, silent, watching. This wasn't going the way it usually did. Most people argued loudly or backed away quietly. This woman did neither. "Ma'am," Mercer said, "you're interfering with a police investigation." She nodded once, as if acknowledging a technical error. "And you," she replied, "are attempting entry without satisfying the Fourth Amendment." The exchange was calm, but the pressure was building. The body camera captured Mercer's jaw tightening. He took a step closer to the door, closing the already small distance between them. "You need to step aside," he repeated. "Now." The woman didn't retreat. She asked again, slower this time. "Please present the warrant." That was the second off-ramp. Mercer ignored it. He accused her of obstruction. He referenced arrest. He leaned into the tone officers use when they expect compliance to follow threat. But the woman didn't flinch. She stood in the doorway in sweatpants and a plain t-shirt, hair still damp, posture steady. "You can either show me the warrant," she said, "or explain to a federal court why you didn't." Mercer stopped talking. For the first time since arriving, he hesitated. He looked back at his partners. They didn't speak, but the uncertainty was visible. This was no longer a standard knock and search. This was something else. Mercer reached into his pocket and pulled out a folded document, holding it up through the gap in the door as if proximity alone counted as compliance. The woman shook her head. "Slide it under," she said. "I need to read it." The hallway went silent except for the faint hiss of the Bodycam microphone. Mercer hesitated again, then bent down and pushed the paper across the floor. Inside, the woman picked it up. She didn't skim. She didn't rush. She read every line. Dates, addresses, allegations, probable cause. 2 full minutes passed with 3 armed officers standing in a hallway, waiting. When the door opened again, the chain was off, and the expression on her face told Mercer the stop that should have ended hadn't ended at all. The woman stepped fully into the hallway, the warrant folded neatly in her hand. The shift was subtle but unmistakable. A moment ago, she had been a resident asserting a right. Now she was someone examining evidence. "This document," she said, holding it up, "claims information from a confidential informant." Officer Daniel Mercer straightened. "That's correct." "Who is the informant?" "I'm not required to disclose that." "That's fine," she replied. "Federal subpoenas are very effective at uncovering identities that don't exist." Mercer blinked. The words landed without drama, but they landed hard. She continued, eyes dropping briefly to the page. "This warrant also claims multiple controlled purchases at this address." She looked up. Dates? Mercer hesitated. That information is in the case file. Then give me the case number. Mercer recited a number. His partner shifted behind him, the body cam catching the movement. The hallway suddenly felt smaller. Which unit are you searching? She asked. Both, Mercer said. She nodded once. What? The warrant covers the entire building. She lifted the paper slightly. A warrant must be particular. You don't have individualized probable cause for both units. You don't even specify which unit is suspected. That makes this a general warrant. Mercer opened his mouth, then closed it. This was no longer a disagreement about procedure. This was an exposure. The body cam captured the sheen of sweat forming along his hairline. She pointed to a line on the page. You're asserting corroboration that doesn't exist. You're presenting assumptions as facts. Mercer's voice tightened. Ma'am, you need to step back. Instead, she asked another question. Which judge signed this? Mercer glanced down. Judge Elaine Porter. The woman smiled, briefly, not with satisfaction, with recognition. I know Judge Porter, she said. She doesn't sign warrants like this unless the facts are solid. The hallway was silent again. One of Mercer's partners looked away. She raised her eyes back to him. Did you prepare this application? Yes, Mercer said. Have you been investigated before for search practices? Mercer didn't answer immediately. She waited. The body cam caught the pause, stretching too long to be nothing. She nodded, as if confirming a detail already known. Here's what happens next, she said calmly. You can walk away right now, or you can proceed and explain to federal prosecutors why you executed a defective warrant after being warned. Mercer's jaw clenched. The paper felt heavier in his hand now, like something that could pull him under. Behind him, his partners exchanged a glance. The hallway wasn't just recording anymore. It was witnessing, and Mercer had to decide whether to stop or make it irreversible. Mercer didn't respond right away. The silence stretched long enough to feel deliberate. His authority, which had filled the hallway minutes earlier, was beginning to thin. He reached for his radio, stopped, then lowered his hand again. The body cam captured the indecision clearly, not confusion, but calculation. Whatever confidence he'd arrived with was draining fast. Who are you? He finally asked. The woman answered without raising her voice. She didn't posture. She didn't threaten. She stated her role. The effect was immediate. Mercer's shoulders stiffened. One of the officers behind him inhaled sharply. The hallway shifted again, not in volume, but in gravity. This was no longer a civilian disputing a search. This was someone who understood the machinery behind the badge and had access to it. She continued, methodical. If you enter without correcting this, she said, you expose yourself to federal charges. Deprivation of rights. Perjury. Pattern misconduct. Mercer tried to interrupt. She didn't let him. You've already created a record, she said, gesturing toward the camera. Your refusal. Your statements. Your posture. It's all documented. Mercer looked down the hallway, as if searching for an exit that didn't exist. He spoke quietly now. We can sort this out with a supervisor. You should have called one before knocking, she replied. That was the moment when the system realized itself. Not loudly, not ceremonially, but in the quiet recognition that this encounter wasn't disappearing into paperwork. Mercer asked for the warrant back. She shook her head. I'm retaining it. You can't. I can, she said. And I am. The radio crackled softly on Mercer's shoulder. Dispatch asking for a status update. He didn't answer. This wasn't about drugs anymore. It wasn't even about the search. It was about a record that would now exist outside his control. Supervisors, review boards, prosecutors, people who would read this warrant slowly, the way she had. Mercer finally turned to his partners. He gave a short instruction. They stepped back. The hallway emptied the same way it had filled, quietly. No cuffs, no shouting, just retreat. Behind a closed door, phones were already being dialed. And by the time the morning finished unfolding, this case was no longer confined to a hallway. It had entered the system. The fallout didn't announce itself with sirens or headlines. It unfolded through phone calls, emails, and files being opened quietly before the workday had fully begun. Within an hour of the officers leaving, the warrant was no longer just a piece of paper. It had been logged, copied, and flagged. By mid-morning, it was sitting on more than one desk outside the police department. The language that had seemed routine in the hallway now looked different under institutional light. Vague assertions, recycled phrasing, confident claims unsupported by specifics. By Monday, Officer Daniel Mercer was placed on administrative leave, not because anyone had proven intent yet, but because the questions were unavoidable. Supervisors began pulling his previous warrant applications. Patterns emerged quickly. The same structure, the same phrasing, the same urgency, often timed for late afternoons when scrutiny was thinner. Internal review became external review. Federal agents requested records. Judges were contacted. One of them asked to see the application that bore her signature. When she read it carefully, the way it should have been read the first time, she didn't focus on what was missing. She focused on what shouldn't have been there. Mercer was interviewed, then interviewed again. His explanations shifted. The confidence he once carried into hallways didn't survive transcripts. His partners were questioned next. Neither was charged, but both were suspended while investigators reconstructed how often silence had substituted for verification. The case widened, not dramatically, systematically. A unit review turned into a departmental review. More warrants raised the same concerns. Searches that had yielded nothing. Homes entered without apology. Residents who had never understood why they were targeted in the first place. Charges followed, not all at once. Carefully, precisely. Perjury in warrant applications. Deprivation of rights under color of law. The courtroom proceedings were restrained, procedural, and unsatisfying in the way real accountability often is. No speeches, no redemption arcs. Mercer was convicted. Sentencing didn't resolve the damage. It documented it. Careers ended. A unit was dismantled. Policies were rewritten. Training hours were mandated. Some convictions tied to earlier searches were vacated. Others couldn't be undone. And the woman whose door had been knocked on that Saturday morning returned to her routine. Same building, same neighborhood, same quiet mornings. The system had responded, but only because it had been forced to look at itself. No one celebrated, because justice, when it arrives honestly, leaves discomfort behind. This case had footage. It had witnesses. It had documentation. Most people don't. If stories like this matter, subscribe to this channel for more documented cases of accountability. What should happen when authority relies on routine instead of restraint? Let us know in the comments.